Welcome to Out of Court and Out of Conflict, your guide to estate law and probate solutions. Presented by Wasinger Law Office. Join us as we unravel legal complexities and secure your family's legacy.
Hey, and welcome to Out of Court and Out of Conflict, your guide to estate law and probate solutions by Wasinger Law Office. Join us today as we unravel legal complexities and secure your family's legacy with experienced attorney Matt Wassinger. Matt, how you doing today?
Doing great, Kevin. How are you?
I'm good. Excited to talk more probate. So now we're getting into asset protection. What exactly is asset protection, and what are some of the misconceptions people have about it? You know, I've heard some people think it's only for people who are super, super wealthy, or, you know, up there in that extra 1% area. Tell me a little bit about it.
Well, I mean, asset protection is pretty close to what it sounds like. It's titling your assets in a way, or placing them in a business or a trust of some kind to prevent creditors, maybe future spouses or anybody else, from being able to get a piece of those assets. So it's quite literally just protecting them from as many things as you can possibly do. But there's different ways of doing that, right? There's irrevocable trusts, which if a revocable trust, which is changeable, is the red wagon. An irrevocable trust is like a safe. You can get in there for only specific combinations of things, but otherwise that's your little protection box in the trust world. And there's a million different versions of irrevocable trusts that have all sorts of different ways you can structure them. But that's the general idea. You're putting it in a safe. They stay in that irrevocable trust for the benefit of the beneficiaries, but they're protected from outside. And the other thing is businesses, setting up business structures and entities to make sure that your assets are protected, you know, at least from the rest of your assets. So putting something in a limited liability company, for example, whatever's in there is the only thing that anyone could go after if they're trying to sue that LLC, that business, right? They could only go after the assets in there, where the rest of your assets are protected. So there's different ways to accomplish that. But the biggest misconceptions are, one, that if you have a revocable living trust, you just have a regular trust, that's providing some sort of asset protection. It is not. The rule of thumb is anything you have access to, direct access to, your creditors have access to. A revocable living trust is that red wagon. It is a funnel to keep things out of probate and keep things available for you and your successor trustees, whether you're incapacitated or after you pass. It's only irrevocable trusts that provide asset protection. That's the number one thing. That is the number one misconception, is that regular trusts provide some sort of asset protection.
I have definitely heard people say things like, "Oh, I don't make enough for that." We talked about that a little bit in the last episode. Is that true? I mean, do you need to be at a certain level of income in order to, or assets in order for this to be something you need to consider?
In some cases, it makes more sense when you have more assets than you don't. You know, there's definitely a cost to doing it, and not only just to set it up, obviously, but to keep it going. An irrevocable trust is very much like a business itself. It's got its own federal identification number. It's going to have its own bank accounts. It's going to have its own processes of doing things. So sometimes that doesn't make sense for people that don't have enough assets to justify setting up that irrevocable trust, or at least setting it up for life in a situation like that. But there's a whole bunch of reasons why sometimes setting that up to spring out of your revocable trust, which we set up when we're designing our estate plans for our clients, to create one that covers a portion or the entire estate to ensure that it is protected from future creditors or future spouses. If you're worried about, you've got young kids like I do, if something happens to you now, there's a good way to set up from your revocable trust for your assets to flow into an irrevocable trust for the benefit of your child and your wife, but that money doesn't get access to any future spouses. So that way the money stays, that little nest egg stays there for the benefit of your wife and kid or kids. So those are the kind of things that we're looking at. We're looking at more about what you're trying to accomplish. And then sometimes the overall amount of assets you have plays a bigger role in making those decisions, but not always. We're focused on your goals specifically and then trying to work around those to the best of our ability.
So what types of assets are typically the most vulnerable and might require special protection planning?
The biggest ones that we pay attention to are, rental properties and businesses. For 90% of people, those are the ones that we're making sure that are set up with that some sort of asset protection. And then again, the after one of you passes, setting it up into an irrevocable trust might be a big life insurance payment, right? Setting that up to funnel into an irrevocable trust so that's protected. So those are some of the things, either a big cash payment that we expect or maybe right away are doing that, or a business or a rental property that we're focusing on. And that's 99.9% of people that are under the estate tax exemption. Those are the main things we're looking at. And depending on if you start getting into higher net worths, you're doing a lot of this asset protection, less for the asset protection itself in some cases and more for the estate tax, avoiding that 40% off the top estate tax once you pass. And that's when the higher level income really plays a part.
So I'd like to expand a little bit on the LLCs you were talking about. What are the advantages and disadvantages of incorporating LLCs or other entities for asset protection, specifically in Florida?
The big thing is it's helping keeping that asset as a loan the only thing that somebody can go after if something happens, right? So the easy example is a rental property. Putting a rental property in an LLC limits the liability that people can go after to that rental property, right? So there's some attorneys that'll say, oh, you can put 3 or 4 properties into a single LLC. I'm also a property attorney. I don't recommend that because if you've got 4 rental properties and someone slips and falls in one of them and sues, they can still try to go after everything in that
They're
LLC.
all connected. Yeah, that makes sense. Yeah.
So you try to separate those out. Now, there's all sorts of variables and things that might not make sense for someone to do that, or they just don't want to, but we want to separate those out. And most important, we want to have 2 members in that LLC because a single member LLC has no liability protection in Florida. It's just as if you own the property in your own name. It's just basically got a fancy title with LLC at the end of it. So you always want to have a second partner member of that LLC in some way, shape, or form. And you want to make sure that you're separating those assets to be the only thing that can be attached if there's a problem with that asset.
Interesting. Does that go just for like LLCs for a business too? Or is that just mostly just more for like rental properties and stuff?
No, it's for everything. I mean, so if you've got a business and you've got a business that's making a lot of money, a restaurant, maybe you have multiple restaurants, for example, multiple locations, but it's all under one LLC and you own it just as a single member. Well, they can go after everything in those businesses, and they can go after whatever they can try to go after in you personally, because you don't have that liability protection without a partner in there. So all LLCs in Florida, you need at least 2 members to be able to have actual liability protection.
Well, I'm not in Florida, but I better write this down. I got to look into that. So what steps can be taken to protect assets from potential creditors or lawsuits in the future?
The biggest things are whether we set up separate LLCs or business, you can incorporate too. For a lot of people that it doesn't make as much sense as a simpler LLC setup, but different business entities, and then your estate planning with the future in mind instead of just right now. Okay, what are we looking at? What if something happens to me in the next 3 years, in the next 10 years? What do I want to happen with these assets? How do we want to protect them? Sometimes it does make sense to set up an irrevocable trust right then, separate from your revocable trust, and have it as its own entity, depending on the assets you have and what you're trying to protect. But a lot of times for a lot of families, especially as you're growing your assets and you're continuing to grow with families that are, younger with younger kids, you don't necessarily want to lock up those assets into an irrevocable trust now, but you want the benefit of one if something happens to you, which is where you build those into your revocable trust to kind of spring into action once you pass, to provide that liability or that asset protection for the benefit of your spouse and your kids or whomever that you've got set up that you want to protect after that.
So tell me, what is a homestead exemption? I've heard of this before. What is that and how does it play a role in asset protection for Florida residents?
In Florida, Homestead is a constitutional protection on your primary residence. They give you the ability, and there's some variables, but for most people, your house and your primary residence and your house has, aside from any liens that you put on it specifically, like a mortgage or something like that, or a federal tax lien, is protected from other liens being attached to it. So Florida's got a very conservative, if you're looking at it from creditors' perspective, situation for Florida homeowners. You're allowed to own that home and no one can come attach some little judgment. You get a credit card debt and they go and get a judgment against you. They can't attach it to your homestead in Florida.
Oh, wow.
And again, there's variables to this because there's all sorts of different things, but most likely scenario for most people is they can't attach that. So it's a really great state and it's a really great exemption if you take advantage of it. And then the other thing is it provides you with the ability in Florida specifically to prevent your taxes from going up significantly. The homestead exemption lets you keep your taxes if you apply for it. Let's say the year you bought your home. You bought it for, the simple number, bought it for $100,000. Property taxes usually go up based off the appraised value of the property, right? So every year it gets reassessed at the appraised value. Well, Florida's homestead rules allow you to keep the value of your property. It doesn't go up any more than 3% from when you purchased it, as long as it's your homestead. So like 2020 to 2021, 2022, and 3, for example, the Florida's home prices jumped significantly. If you had bought that house for $100,000, you'd still, in 5 years later, you'd probably only be at about $110,000 at your taxes. But if it wasn't, you'd be probably at $250,000 at your assessed taxes, right? Mm-hmm. It provides you a huge amount of benefit and just a little bit of personal protection from all sorts of creditors out there that not all states have in place.
So let's say I want to just say, I'm going to transfer assets to family members or trusts. That'll be my asset protection. Good idea or bad idea?
Well, it depends on how the family members are getting those assets. If you're adding them to your assets, bad idea, because now you're just opening up not only your own liability, but whoever else you put on that account on that asset, their liability now comes into play. Anything you have access to, your creditors have access to. So you put your adult child on the property, he goes and gets in a car accident, they decide to sue you, they can come after that too. So giving things away, the less assets you have, the less they can go after. Mm-hmm. But depending on how you're planning on doing it, if you're doing it as an estate planning trick to hand it down eventually when you die, that's a bad idea for asset protection. But trusts and business entities and different versions of those and variables of those are the best way to help set up asset protection and minimize your liability as much as you possibly can.
Yeah, my family members would just spend it anyway. They wouldn't hang on to it for me. What role might insurance play in asset protection within Florida estate planning?
Well, so a couple different things. One, you could do an irrevocable life insurance trust, which essentially you put a life insurance policy within the trust and you allow it to gain value and it stays protected in this irrevocable trust. So as it's gaining value, it eventually goes down, it stays outside of your state. It's for estate tax purposes, and depending on your net worth, makes a lot of sense. But the other thing, mainly for asset protection, is life insurance helps replace whatever income you may have provided for your family while you were alive, at the very least. So it doesn't necessarily create asset protection on its own, but it helps protect the assets you have down the road, whether that's your assets, you're talking about your kids being your assets, or the value of things that you have, because you can take those policies and have them funnel into your irrevocable trust once you die. And that's asset protected for the benefit of your remaining spouse or kids or whomever your beneficiaries are.
Oh, so that's cool. So you can actually then protect the money coming from life insurance as well through the whole plan.
Correct. Yeah. And that's what we recommend for a lot of people that are, around our age with younger kids, is if you're not trying to lock up, because once you put something in an irrevocable trust, for all intents and purposes, it stays in there. That's what the purpose of it is. You can't really get things out of there easily. If you can get things out of there easily, it's not a very good irrevocable trust.
It's not irrevocable. Yeah.
Your clients can get it. So having the ability to take some money that's not taking it away from let's say your wife and kids now, and it's going into this irrevocable trust for their benefit after you pass, that no one can go after. That you can set up protections for, so it stays in a asset protection vehicle for the benefit of your family that they can kind of rely on and don't have to worry about someone coming after it.
So when it comes to strategies for asset protection, how frequently, should someone listening to this, taking notes, think about reviewing and updating that within their estate plan? Is that something that you need to do often, or?
We recommend and build into our estate plans every 3 years, a free review.
3 years, okay.
Yeah, at the very least. I mean, it's all variable, but most of the time, every year might be a little too much. We're already in August of 2024 somehow.
Yeah, I agree.
So every year might be a little much just because you're going about your day-to-day life. But
yeah, you goes fast.
You want to look at what's happening. If you have some major life change, you had another child, you've bought another property, you've come into a bunch of money, whether that's from you're working, lottery, your family, however it comes, those are things you want to think about. We should review this with our estate planning attorney. But at the very least, do it about every 3 years, because even if everything in your life is exactly the same, the law changes constantly. And so we want to make sure that we're taking advantage or avoiding any pitfalls these new law changes have created.
Are there a lot of law changes each year when it comes to estate planning and to asset protection?
Yeah, and depending on what your estate is, some of these have no effect on your day-to-day life or your estate plan, right? But some of them have massive impact and changes. And so we want to make sure that we're staying ahead of it. And again, these changes take place all the time, because no matter who's making the laws, whatever side of the fence they're on, everyone is doing it saying they're helping this person or helping that person. But at the same time, that most of the time that's taking away from somebody else in one way, shape, or form. You're saying
that the policies that lawmakers make don't benefit everybody?
That's crazy. Crazy, I know.
Weird.
So we would just want to make sure that we're on the right side of whatever version of that law and how it affects your family stays.
So for you guys specifically, for your firm, like what sets you apart when it comes to helping Floridians protect their assets, and why is it essential individuals hire your firm versus trying to do this on their own? We talked a little bit about this with the probate stuff in our last episode, but once again, tell me why people need to hire someone like you rather than just figure it out on their own.
Well, the first thing is we set up our way of handling estate planning so your plan actually works. That's why we bring you back for that 3-year review. We want to make sure that it works. Getting it done 20 years ago and forgetting it very rarely is going to work out the way that you want it to. So that's the number one thing, getting attorneys that are making sure that, you set up a trust, they made sure that your assets get in there, right? The other thing is attorneys that actually listen to your goals, because if you don't let them know, or they're not asking what you're trying to accomplish, then the estate plan is not going to be built to suit your family necessarily. It might get lucky and some of it cover it, but mostly you need to figure out what you're trying to accomplish and have your attorney help you, guide you on the right way to do that. And the biggest issue of doing it on your own is you don't know what you don't know. And there's a reason why people specialize in whatever career path that they choose, is so you can go get that information in the right way of doing it. Do they know that their beneficiary designations overrule their will? Do they know that that Florida's financial power of attorneys kick in the second you sign it? Some other states allow them to spring into effect once you're incapacitated or unable to handle things on your own. That's not the case in Florida. Once it's signed, that power of attorney is usable to whoever you put in charge of that. Do they have a backup listed to their backups? Because a lot of times some people are unwilling or unable to handle the role that they've been given. So they need someone there listed to go to the next person, or you're going back to court. Little things like that you're just not thinking about if you don't know, if you're not in the process or have been through the process of estate planning. And doing it on your own is just like doing your own electrical work. You might get it right, or you might end up blown back across the room because you didn't flip the breaker properly, right?
Happened once, Matt. You don't need to harp on me, all right? I knew I shouldn't have told you about that. I think we live in a society where we can do so much on our own these days, right? There's a website for everything. There's an app for everything. So I think so often people are like, "Oh, I can do that. That's not a big deal." And everybody listening has been in a role or is in a role where they've experienced people saying that stuff. So like I said last time when I talked about flying across the room from my electrical snafu, there's like I said, there's a reason that there's experts doing this stuff.
Yeah. And this, as we talked about before too, it's the reason why we both have a CPA doing our taxes instead of doing them on our own, right? Like it's time consuming, and you might have done it wrong the first time, and it's not a great feeling, and it won't be great for your family if you screw up the estate plan and they think it's going to go one way, and then they spend 12 to 18 months in probate court trying to figure it out.
Yeah, that's a big oops. Big oops.
Yeah.
All right. Well, thanks everyone for tuning in to Out of Court and Out of Conflict with experienced attorney Matt Wassinger. For more information or to connect with Matt, you can always visit wasingerlawoffice.com or find him on social media. As always, please hit that like and subscribe button. Leave us a review in the comments. We greatly appreciate it. Matt, awesome to talk to you as always. Thanks for being here.
Thanks, Kevin. It's always a pleasure.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one. And be sure to follow us on social media.